Hi all, welcome to our live Q&A session on recent employment law changes that started in April this year. This is one of many webinars that have taken place via Trinova Group, and the brands which Trinova Group consists of: Trust in Soda, Broadgate Search and BioTalent. I'm Holly Farmer, the Client Relationship Manager at Trinova Group. Thank you so much for joining us this evening. We hope this will be helpful as we discuss these recent changes and how this may affect you as an employee or as an employer. Most people have overlooked these changes due to COVID, but Alex will be more than happy to offer any guidance and advice throughout the webinar. The main areas for discussion today are recent employment changes, how it's affected permanent employees and employers of permanent employees, tips and advice on this moving forward, and then an option for Q&As throughout in the chat box, which I'll highlight in a moment. So a bit of housekeeping before we get started. You'll all be muted upon entry, but we want to make this webinar as engaging as possible. So please do feel free to ask questions in the chat box, which should be on the right-hand side. And just so everyone is aware, this webinar will be recorded and will be on our Trinova Group YouTube channel. Perfect. And our panel today, we have Alex, Director and Partner in Loch Employment Law. Alex is a regular employment law commentator on BBC Radio and is experienced in delivering presentations and webinars on employment topics to various groups and societies. We also have Sally, our HR professional for Loch Associates. The topic of employment law is not the most thrilling, so we've tagged Sally in to cover myths or facts, you decide, around employment law that she's encountered in her role as a HR professional, with some interactive polls for you guys to participate in. So, hi Sally, hi Alex, thank you for joining me. Let's kick off with the wildest thing you've ever been asked within the theme of employment law. Alex, do you wanna go first?
So I think one of the wildest thing I was asked was really, and it was totally off subject to what we were discussing, was do you want to know about my partner, because they told me that they murdered someone once and they've hidden their body. Do you want to know about that?
What do you do?
And my response was, well, unless I don't think it's relevant to what we're discussing here. And they were like, well, not really, no. What? So I said no.
Right, okay. And
we moved on.
You have to report that? Did you have to go to the police and be like, somebody been... fair enough. All right, well, thanks for that, Alex. Sally, what's yours?
I once had a manager raise a complaint with me about a member of their team, because the member of the team had sent them a text message with a picture of some long, over-the-knee sexy black boots, asking if they would wear them to work the next day, and she wanted to know whether that was inappropriate or not.
Right, well, that's a good start to what's to come. And then before we start with the sort of questions with you, Alex, shall we do two polls to begin with, just to get the live polls rolling? So Lucy, we'll need you to, there we go. Right, number one, Sally, do you want to go for it?
Yeah, so these polls are just some questions about whether it's illegal for an employer to give a bad reference. So is that true, false, or are you unsure? And you can just mark it on there. The second one is if an employer makes an employee redundant and the employer can then recruit again within 2 months, have they got to offer that job to the employee? Oh. That's obviously quite topical at the moment.
Yeah.
And the final one is it okay for employers to use 0 hours contracts?
No, that's what they have in New York, isn't it? Lots of people tend to be on 0 hour contracts.
Yeah, they're getting a lot more popular over here as well at the moment.
Ah, so they are. That is...
Well, but is it okay for them to use them?
Oh.
You're giving clues away, Sally.
Spoiler alert.
Okay, so have we got the results of those?
Drum roll. Da, 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 da. Oh, Lucy. Hey.
So there we go. So people think that it is false. So it's illegal for an employer to give bad reference. That's right, it is false. So you can give a bad reference, but it must be factual. So you must be able to back it up with information that you know and you can prove about that employee. We actually advise most of our clients to just give a factual reference. So this person works here from these dates in this job, because then there's less reason for anyone to come back on any of the issues. However, we do advise our clients to take up better references than that. And there are ways of getting out more information from somebody. Sometimes a phone call's always good. Just ask somebody, how was this person? Silence is very loud in that situation. So the next one is, do you have to give somebody, offer somebody a job if you've made them redundant? That is also false. Well done, everybody. You all got that right. You don't have to offer them a job, because actually it might be a different job. It might not be something that they can do. You've made them redundant. Your relationship with them has ended at that point. And actually your needs could have changed within that 2 months in a very different way. It would be different if they were still serving their notice period. You might want to consider if that was the case. But actually, if they've left your employment, then you wouldn't need to offer them that role. And you're all right, you can use 0 hours contracts. So it's okay for employers to use them, and in some circumstances they do work really well, but it is advisable that you do get them drawn up by an employment law firm, and that they do suit your needs, making sure that you've understood that they are still employees and therefore all elements of employment law still apply, even if they're only working 1 or 2 hours a week for you.
Oh, that's interesting. I've worked in recruitment for quite a long time now, and I've literally never come across a 0 hour contract. So that's quite interesting.
Yeah, a lot of places, hotels, cafes, they use them because they flex people up and down. Some people really like being on them as well because they can pick and choose their hours, but it does depend how the contract is written. A lot of them tend to be able to say, I'm available these hours, so I can always work on Monday, Tuesday or Wednesday, for example. And you say, okay, we need you this Monday and that Wednesday.
I know I would have liked it as a student when I had a hangover.
Yeah. I think that's where they're really common. I was going to add as well, I think they've done surveys, it's had a lot of bad media attention, 0 hours contracts, but actually a lot of the stats that I've seen, most people on 0 hours contract like and want to be on 0 hours contract because it's quite flexible for them. But there certainly are some bad employers who have abused it, which is where those bad headlines are coming from.
Yeah, do you still get holiday if you're on 0 hour contract? Because is it just by how many days you've worked?
Yeah, it's based on the hours that you've worked whilst you're there, so it's prorated.
Okay, that makes sense. Right then. So shall we kick off with the questions now then, Alex? You ready?
I'm ready.
We'll do half and then we'll do some more polls and then we'll do the other half, so it's 4 in one go.
Sure.
So number 1, go on.
Well, this is really just at a glance as we've got on there. So really what we're trying to focus today on, with some sort of more light-hearted bits in between, is just to make everyone aware really of some changes that have come in at the beginning of this year. And I think what normally, we often in employment law will have some changes in around April time, but we've just experienced with some of our clients that there's a bit of a worry in terms of, quite rightly so, COVID-19 has overshadowed a hell of a lot this year. So it's really, this is just to highlight what has changed and possibly hasn't sort of had the media attention or interest in at the start of this year. And really just to make everyone aware of those changes that have come in. So first one we've got on there is national living wage and national minimum wage increase. I'm going to go through those changes every year, but it's particularly large change this April. We've got some changes to contracts of employment. It's really how those contracts are formulated and when you have to provide them. There's a change to the way certain holiday pay calculations have to be carried out as of from this April. We've got national employers' national insurance contributions have changed slightly in terms of how they're applied to certain types of termination payments, worth being aware of. New leave has come in, the right to parental bereavement leave and pay. And then we've got 2 which are really focused on agency workers. So removal of this excitingly named Swedish derogation, and then we've got some key information documents that are now required. And the final one there was due, this is really on there to flag to people, because that was due to come in this April, having been postponed from the previous April, and it's now been postponed again because of COVID-19. So that's the extension of payroll working rules, IR35 rules, basically.
Heard that a lot. All of my clients been panicking about that one. So
yeah, keeps getting delayed.
Yeah, 100%. Okay, well, with these in mind then, I suppose I'll start with the questions. They're all very much based on the topics highlighted here. So question number 1, what's the minimum wage, and how about furloughed employees? Do they have a minimum wage? How much does an employer need to pay them?
Sure. So the current national minimum wage for those over the age of 25 is £8.72. We've got it on the slide there. And that's as I say, it goes up every year, tends to, but that's a 6.2% increase, which is one of the highest we've ever had. I think it's 3 times inflation. And then it's then staged in terms of ages. So we've got 21 to 24-year-olds, they've gone up to £8.20 an hour. 18 to 20-year-olds gone up to £6.45 an hour. 16 to 17-year-olds, they're now at £4.55 an hour. And then we've got this sort of special apprentice rate, aged under 19, and in the first year of apprenticeship, £3.90 to £4.15 an hour. And then to answer that second part of the question, we've had this a lot. This query's come up with our clients a lot in terms of how does national minimum wage affect payments for furlough and furlough calculations, which in themselves are very complex. Unfortunately, we're not going into today. But in essence, it doesn't really impact upon them. The reason for that is twofold, really. One of which is if you're furloughed, i.e. you're not working, the national minimum wage regulations don't apply. But it's more because of the way that the furlough calculation works, in that they look at the period predating the 19th of March this year. And obviously this update has only come in from April. So the furlough calculation predates this change.
Yeah. Okay. All right. And then the second question is, what should an employer issue should an employer issue an employment contract to a new member of their team? Is it illegal for them to get started without that contract?
Sure. So this takes us on to the next slide that we've popped up on here, which is, and just tracking back slightly on this one, up until this April, we had almost like a prescribed set of information known as a written statement of terms information that you had to provide to an employee as a minimum within 2 months of them starting employment. Since then, we've had the implementation of something known as the Good Work Plan, which some of those listening may have heard of. And one of those recommendations was that information is tightened up upon, basically. And in essence, that's what's happened. So we've now got a requirement that instead of that 2-month period, you need to provide the contract of employment, written statement of terms. Usually they're one and the same thing, but technically different. You have to provide that within, basically by day 1 of employment. So in most cases, in terms of a recruitment process, it's now about thinking and making sure you've got those terms drafted before that person starts effectively, rather than you having that bit of time to prepare it after they start. And I work with lots of employers who didn't do it for a long period of time anyway, but you should be doing so.
Is that the same with contractors? Do they have to have the contract before they can go on site?
Contractors is a bit different. It depends what we're referring to as contractors. Most people, when you talk about a contractor, we're talking about someone who is self-employed. So if they're self-employed, this only applies to employees. And the second important change is that it now also applies to workers. Right. So we're getting into slightly tricky territory in terms of that employment status, as to whether the contractor is truly self-employed or whether they are not quite at that level and they're therefore a worker, which also impacts upon your favourite IR35. This is the other big change really to be aware of. Second bullet point there is this right has now been extended to all workers. So really I would say for those people who use, for example, casual worker type agreements, often when I've drafted those in the past, they are very, very basic, a lot more basic than your average employment contract. So it's to look out for, and probably I would recommend reviewing those casual worker agreements.
Right, okay.
To make sure they now comply with essentially these terms which have to be provided both employees and workers.
Perfect. Okay, thank you. And then what recent changes need to be put into employee contracts?
Sure. So I think that takes us on to the next slide in terms of what are the key changes to those terms. So as mentioned, we used to have a whole set of terms. That hasn't massively changed. We've just got some additions to it that you have to include, and you now have to do it for workers. So the first one we've got on the slide there is working days and hours and whether these are variable. Frankly, several of these, if you've got a decent contract, you're probably going to have that in. I mean, you would expect that to be in a contract, so I'm not so worried about that. Second one is paid leave entitlements. That is probably not in lots of contracts, so that's worth definitely looking at. You know, and what we've started to do, for example, is reference the fact that there's all sorts of paid leave entitlements, such as maternity leave, paternity leave, and just reference that in the contract to make sure that that document is complying with these new legislative changes. Third one there, benefits. Possibly that's in your contract, but again, worth checking, you know, making sure that you do state whether there, for example, is a car allowance, state whether there's health insurance, if they do exist. Then we've got those probationary period terms. Now, probationary periods are really, really common. I would really recommend that all employers really have them. Normally recommend that they're about 6 months period. But what's changed in that regard is you now have to state whether there is or is not a probationary period. So if there isn't a probation period, you have to say there isn't a probation period. If there is a probationary period, you need to set out the terms of that probationary period. So often people will say that you have, for example, slightly different notice period if you leave employment during probation. And often you might say that there's going to be more reviews. So you need to state that in that document if it's happening. Final one there is training. Training is a bit of a funny one in that, unfortunately, the legislation isn't very clear over what they really mean by that. So that's not hugely helpful, but what you should essentially doing is setting out any specific training entitlements that the individual has. So in certain industries, you're going to have things like you have to do safeguarding training, for example. So you're required to now state that in those terms. In most cases, there's not really any specific training other than things like induction training. So most cases, we're tending to put in contracts to sort of say there's no specific training other than the usual induction process.
Okay, perfect. Thank you for that. And then number 4, do employers need to issue a new contract to their existing team members with the new changes, or does this only apply to new employees?
Sure. So this new change only applies to the new employees that are coming in post 6th of April, basically, this year. But for old employees, basically, you don't need to update their contract. However, they do have the right to request that you do so and comply with the new terms. Quite unlikely most employees are going to do that. The occasion it's going to crop up is probably when there's been a fallout or you're having a dispute and they think, I'm just going to be difficult. So if they request it, you then have to provide it within 1 month of that request. What I have been saying to employers is if you are updating those contracts, which I would recommend you look at, for new employees, it might make sense just to update everyone's at the same time in any event.
I mean, because I know you said there's been some changes to the minimum wage and stuff like that. If you're on a lower wage, but you know you can now get more, would that then apply now moving forward, or would it only apply to people starting a new job in April?
So the minimum wage, if you're working, the minimum wage should be increased. Okay. Basically. So you have to be on that minimum wage.
Perfect.
As a minimum.
All right, and that Sally just popped up perfectly in time there, ready for the next round of the polls. Over to you, Sally, in the studio.
Lovely. So the polls should be coming up now for you to have a look at. So the first one is an employer can make an employee redundant whilst they're on maternity leave. True, false, unsure. So get your answers into that one. The next one it doesn't mean anything, is that gross misconduct means that an employer can sack an employee on the spot. True, false, unsure.
Okay.
And the final one, employers can't ask any questions about a candidate's personal life during an interview. True, false, unsure. Just give you a couple of minutes to pop your answers in there. And then I think we're going to share the results. There we go. So an employer can make an employee redundant on maternity leave. Yes, you can. You've got that right. Well done. Give yourselves a pat on the back. So you can make somebody redundant whilst they're on maternity leave, as long as their role has become redundant and it's not because you don't want somebody with a child working for you. That would be discrimination. But if their role and the role that they're carrying out for you is no longer something that you need, then you can make people redundant in that situation. That comes up quite a lot with our clients. They quite often won't touch somebody because they're on maternity, or I can't do that, they're on maternity, or they're pregnant. You just have to take away who is doing the role and look at the role itself. So gross misconduct means an employer can sack an employee on the spot. So some say true, some say false. So that is, I just had to check the answers then. I do know the answer. That is false. So it's true in a way, in that if that gross misconduct has been found to be gross misconduct, then you can dismiss someone. But in order to dismiss someone and end their contract, you need to follow through a process. So the process would mean you need to investigate it and you need to hold a meeting with the employee. ACAS say that meeting needs to have reasonable notice to it, which reasonable we normally say is 48 hours. They need to be able to bring somebody with them, so an employee rep or somebody who works with them. So they need to be able to have a companion with them in that meeting. So there is a process that can be followed. If you watch Holby City, of which I'm an avid fan, you will note on many occasions there is no process followed, and it irritates me quite a lot. So TV programmes do help us dispel that myth slightly, but generally a process needs to be followed. If somebody, if you don't follow a process, then it would give them grounds to take a case against you. And the final one, I bet Alex is itching to pitch in on these. Employers can't ask any questions about a candidate's personal life during interviews. So that, I can't see the results, there we go. So some people say false, some people say true. So the interview isn't about an employer's, the candidate's private life. However, you can ask questions. And there are ways to ensure that those questions don't become something that discriminates against them. So the reason we think we can't is because we think if we say, well, who's going to look after your kids then while you're at work, or something like that, then we're discriminating against them. If they then don't get the job, they can say it's because that, you know, because you felt that they've got kids and they wouldn't be able to give you their full attention. But actually there are some questions and some ways that you can ask certain things. So we always ask, you know, tell me something about yourself that's not on your CV. And if we ask that to everybody, then that's absolutely fine. That person then chooses what information they're going to give to you. What do you like to do in your spare time? Sometimes my top tip here is people want to know, will this employee be able to give me more than a 9 till 5? You know, or are they going to be running off to get the kids every night, or are they going to be, you know, late for work because they've got certain things to do in the morning? And so you need to think about, if you want to know that sort of information, think of another way of asking it. So we always ask, is there anything that you do outside of the work that would stop you working the occasional evening? That's a fine question to ask, because actually the job involves working an occasional evening. It's not saying, it's not put to you in a discriminating way, but it does get the information that you want at the end of it. So yes, you can ask questions about a candidate's private life. You just need to be a bit careful what they are.
Yeah, we recently have done a bit of training on contractors over in the US because we've got a branch out there now, and apparently it's like crazy over in America how strict they are with this policy. Like you literally can't ask anything about religion or any of those types of questions because lawsuits are a lot bigger in America than they are here.
Yeah.
You've got to be super careful.
I think you need to come from it from a point of view of what do you need to know, and make sure you actually need to know that from everybody.
Yeah, 100%. Perfect. Thanks, Sally. We'll see you
Pleasure.
again. 4 questions time. So, Alex, next one. Are you ready to go again?
I am, yeah. Let's do it.
What changes do employers need to know about when calculating holiday pay? And is there a minimum or maximum amount of holiday pay that employees are entitled to?
Sure. So there has been a change to the way holiday pay is calculated. It is really focused on those employees, workers who are working variable hours and have variable pay. So obviously, if you're on a standard salary and your pay never varies, this won't impact upon you. The calculation is relatively simple. But if that's not the case, we previously used to have a reference period where you'd basically count back 12 weeks from when the person was going to take holiday, take an average of what they had earned, because it's going to fluctuate during that period, get that average and use that average as what you pay them when they take that week's holiday. Now, new rules come in. In essence, you have to take 52 weeks. So you take it across a year, in effect,
right?
As to what they've been earning. Idea is obviously that it's a fairer system, that when they go on holiday, the amount they're paid reflects in a much better way what their normal pay is. And that's really the kind of theme, the golden rule, I suppose, of holiday pay calculations now. You know, you need to reflect when someone's on holiday what their normal pay would be.
Yeah.
And that actually goes on to the next bullet point that's up on there is, you know, you've got to look at voluntary overtime possibly, then impacting upon what people get when they're on holiday, as well as results-based commission.
Is there a minimum or maximum amount of holiday that you can have? Like if you are an employer?
So if you're employed full-time in the UK, you have to get the minimum amount of holiday, which is effectively 28 days or 5.6 weeks.
Right.
And part-time is prorated. There isn't a maximum amount. I know that some companies, is it Virgin? I want to say Virgin, say to their employees, you pick how much holiday you want. There's no limits.
Just with tight deadlines that they have to meet, otherwise they get fired.
Yeah, but exactly. But what's interesting about that, I think, is that in many of those companies, it ends up with people taking less holiday.
Yeah. I suppose because you'd feel more sort of, you don't have to take the holiday, but you need to get your deadlines done. So you probably
so it's definitely an interesting little, a bit of a marketing ploy, some might say.
Again, I think that's what they do a lot in America because of the 0-hour contracts.
Yeah.
Good to know. And then question number 2, what NIC and tax do employers need to pay on termination payments?
Sure. So this has changed a bit, but I want to reassure people, and we're probably going to have to step back a little bit. So the kind of scenario in which this is most likely to arise is the classic scenarios where there's possibly been a fallout between employer and employee, and they come to a settlement deal. Often that is wrapped up in something known as a settlement agreement, which is basically like just a formal contract and agreement between the two as to how they're going to end that relationship, usually with the employee saying, I'm not going to bring any claims against you, employer likewise. So in those types of circumstances, if done in the right way, there is a tax threshold that essentially enables an employer to pay up to £30,000 as a compensatory sort of gift payment, ex gratia payment.
Lovely.
That has not changed. What has changed is the tax treatment on the amount over 30,000. So if you're going to pay 40,000 under this type of arrangement, you can still pay the 30 if you do it properly in the right way as a tax-free sum. But the remaining 10, instead of previously, you would just pay income tax on. Now the remaining 10 is subject to employers' national insurance contributions, which is obviously, we've got on the slide there, 13.8%.
Mm-hmm.
Couple of things I would just highlight really with that is it's one, be aware of it. Two, just factor it in, because actually that does increase the cost of it when you're looking at those types of negotiations and payments being made. And three, probably just make your payroll aware as well.
Okay, thank you for that, Alex. And question number 3, who could take parental bereavement leave and what is it?
So this is new as of this April as well. And essentially this is for employed parents who have lost a child, so the child has died. In terms of parents, that is quite a wide sort of definition. So it includes what you would expect really in terms of people who have adopted, guardians of people with parental responsibility over the child. Mm-hmm. And it includes stillbirth from 24 weeks of pregnancy, as we've got on there. So essentially it enables people in that situation to have a right to take 2 weeks away from work, and they have to take that within 56 weeks of the event. They can take it in 2-week full block or 2 separate week blocks. And it essentially works quite similar to, it's a bit like paternity leave in some ways, in that you are eligible to receive a statutory payment, basically, if you've got more than 26 weeks service. Right. And that payment works very much the same as paternity leave. So I think it's currently £151.20 a week.
Oh, wow. I didn't realise it was so low.
Yeah.
Right.
Yeah.
That's
it's massive.
Perfect. Okay, question 4, and actually the last question. What rules have changed for agency workers, contractors or off-payroll staff?
Sure. So Swedish derogation sounds very exciting, but it's really not that exciting. But in short, is again one of these, just be aware of it. So if you're working with these types of contracts, you probably will know it. In essence, we have something in Europe known as the Agency Workers Regulations. Well, they were implemented into the UK, and the main purpose of those types of regulations are to, certainly after 12 weeks of the agency worker starting work, to, in most cases, give them parity, so equality in lots of aspects, to the permanent staff who are working for that entity. And one of the weird exemptions to that was this Swedish derogation, which essentially said in certain types of contracts, everyone's got parity, except you can, in certain cases, pay the agency workers less.
Right.
That rule has now, and it came in for a lot of criticism, basically. So eventually that rule has now been removed. And if you were using those types of contracts, you needed to have, by the 30th of April, but possibly look at it now if you've not done so, notify those employees that they no longer apply.
Right.
And then the second change, which also impacts on agency workers, and it's a bit like, it's in the same vein really as the employment contracts, but to a lesser extent, in that we have just a tightening up of the key information that you have to provide to those individuals. And it's basic stuff, as you would expect really anyway. So the name of the employment business or agency, what rates of pay are, who's going to pay the worker, and the level of fees and deductions a worker can expect.
All right, thanks, Alex. Well, I think that's it on that side of things. And then Sally, to round it off, 3 more facts/myths of polls, please.
Okay, hi.
I love how you pop up.
So the first poll, there we go. So can an employer, no, is it true that an employer can sack an employee with less than 2 years service for any reason? Bear in mind, this is not Holby City. So pop your answers in there. Number 2, during an employee's probation period, they don't have the same employment rights. And number 3, if you're a parent, you're entitled to ask to work part-time. So we've all voted and we're going to get to see those results now. There we go. So employers can sack an employee with less than 2 service for any reason. So some people said it's true, some people said it's false. It's actually false. So you can't sack somebody with less than 2 years service for any reason. You need to have a valid reason. And that reason needs to be something related to how they carry out their role at work. The reason for that is if you've got less than 2 years service and you're dismissed, you would be able to bring a claim against the employer for discrimination. If you felt that you've been discriminated against, you wouldn't be able to bring a claim for unfair dismissal because you don't have the right for unfair dismissal until you've got more than 2 years service. But you would need to be really clear with somebody what the reason you were dismissing them for was. You don't necessarily have to follow a process in the same way if they've got less than 2 years service, but you would still need to inform the employee of the reason for terminating their contract with you. And it is in that situation a termination that would involve you paying notice out to them. So hopefully that clears that up a little bit. So during an employee's probation period, they don't have the same employment rights. False, that is false. They have exactly the same employment rights as anybody else. Admittedly, they need to pass that 2 years threshold before they can claim unfair dismissal, but they've got exactly the same employment rights from day one as anybody else does. They accrue holiday, they're entitled to their statutory rights, etc. And you all got that right, well done. If you're a parent, you're entitled to ask to work part-time.
I've not heard that one before.
So you are entitled to ask to work part-time. It is true. However, everybody with 26 weeks service is entitled to put in a flexible working request. And it does say only ask. So everyone's entitled to ask, but there is a statutory right, if you've got 26 weeks service, to put in a statutory flexible working request to your employer. It used to be the case that you had to be a parent, but now actually it is for anybody. So you are entitled to ask. It doesn't mean that you have to say yes though as an employer. So there are certain there are certain rules in which you need to form an argument if you want to turn down a request for flexible working. So whether that's working at home or it might be working part-time. I think we'll get a few more people wanting to work at home at the minute. And you'd need, if you didn't want that to be a solution for your business, you would need to make a business case around why you felt it wouldn't work for you. But that most businesses would have a flexible working policy. And if you haven't, get in touch, we can write you one. That's that on that. There are some questions on the
Q&A. Whoops, I forgot to ask for out. So you've got a couple queued up now, Alex. You ready?
That's all right. Let's go for it.
So, hi. Will it be possible to get hold of the presentation slides after this?
Yes. I think that's an easy. If they're all like that, it's easy.
Where are we going to be putting it? Is it going to go on the Trinova page? And should we also share it on social media?
Yeah.
Perfect. And then the next one, it's anonymous again. In using 52 weeks holiday pay calculations for each holiday taken, do you then go back 52 weeks extending for holiday already taken in the reference period?
Do you go back extending the holiday during the reference period?
I'm going to read that one more time from the top.
Yeah, I think what they're getting at is you do take out some weeks if it's basically weeks where you're not being paid or working. So there are exemptions to it, yeah, where you might have to track back an extra couple of weeks in certain circumstances.
Okay, perfect. And then Hina, there's another question here. So we employ staff on fixed term contracts as we provide seasonal work from February to the second week of December. We normally pay their holidays upon leaving work, i.e. end of fixed term contract. They are allowed to take unpaid time off during this time. Should you be paying holidays at the end of their fixed term contract?
Yeah, that's quite an interesting one because it's quite common to do what is commonly referred to as sort of rolled up holiday, where people are doing, casual work or very short amounts or fluctuating hours. And it does make a lot of sense in those circumstances, like 0 hours contracts, for example, to just apply calculation, roll up the holiday, and then pay them it, effectively paying their holiday entitlement in lieu. So it is done quite commonly. You get into a very sort of legalistic argument as to whether or not you should or shouldn't be doing that. I think probably based on the case law we have in Europe, it is, let's say, certainly would be frowned upon. So I think you technically shouldn't really be doing it. But all that said, there are lots and lots of companies that have done it for a long period of time. And the bottom line is, if the employees are happy with that and that works for the organization, then sure, you've got to take into account the sort of risks associated with that. But often that is the way that people work it. You could, of course, because they're actually, those individuals, they're with you quite a long period of time. So you potentially could do it where you are allowing them to take holiday. But clearly, especially if you're letting them have, unpaid time off. So I think the answer is technically you probably shouldn't be doing that, but the risks are relatively low for you, especially if all the employees are happy with it and it's the way you prefer to operate.
And Hina, just again, what would be another way around it?
Well, another way around it is you make the individuals take holiday during that period. So you work out what their holiday allocation would be for the amount of hours and time that they're working. And then you say to them, this is the amount of holiday you would accrue during that period of time. Let us know what days you're going to take off. And it might work in that particular example, but a lot of example, that's just not hugely practical, which is why a lot of companies do it the way that they're doing it.
Okay, and the next one, it starts with a cheeky question, so brace yourself, Alex.
Yeah.
What is the pay position for employees coming back from holiday, e.g. Spain, and they have to self-isolate, are unable to work from home? Do they need to be paid, provided contract is silent, employee not ill, so not SSP, and cannot be furloughed?
That's quite interesting. We've recently done an article on this, haven't we?
Yeah.
It's not my article, but it's gone onto the website. So definitely after this, have a look at our website, and there's an article on there that deals exactly with that point. And I know it's something that Sally's been dealing with, so she may be able to add to this. But basically, you've got to feel sorry for some people who have gone out there not knowing there was going to be this quarantine period. And then suddenly it's come in. I think that probably does make a difference in terms of the handling of it by an employer, certainly. If you go now knowing there's this quarantine period as compared to those people who are already out there when it came in. But essentially, an employer can take a hard line with it and could be saying effectively, ultimately, well, you're required to be at work. It's not my fault that you've gone abroad. You've chosen to do that. So I'm not going to pay you during this period where you're quarantining, potentially. But I'm not saying necessarily go down that route, because I think it's a tricky and understandable situation these people are in. I think it is definitely one of those. You just need to discuss it with the employee and think about the ramifications. Because one of them, and this may be in the article as well, is that if you basically say, well, we're not going to pay you anything, those employees might sort of just start coming in or saying they're going to be seeing other colleagues, etc. earlier, which is not necessarily something that you want.
Yeah. I mean, that's actually just happened to my sister. She went out to Spain to visit my mum, and as it's just come into play now, and she's a teacher, so she's pretty stressed out. She's coming home from a holiday early now, so that she has isolated in time.
Yeah, so we do have an article on that on the website, if you wanted to go and have a look. Some of the options that it describes are whether somebody's got any holiday to take, whether they could make up the time. But it does go as far to say that actually it's probably a good idea to be thinking about the future, because the quarantines may happen again, and we need to really think about what our stance is going to be. So as Alex says, you may be really sympathetic to people in Spain now, but you might want to make an announcement or a statement to your team that says, if this happens again, this is the way we will deal with it. just so that you're not stuck in a loop of the same thing happening all the time. And you could go as far as issuing an instruction to your staff to say, we do not want you to travel abroad. You could say that. Whether they take heed of that or not is a different issue. But yeah, look on the website, there's an article on it.
Perfect. What I'll do as well is I'll link it onto our Trenovo website so that people can access it on there as well. Perfect, with the slides. Does anybody else have any questions for the Q&A box? I'll wait a second and just see if anybody wants to type anything on. I think we're done. I think it was answered very well. Thanks, Alex. Perfect.
Thank you.
Amazing. And then that's about it from us, I think. So thank you both for joining us. Thanks for everybody watching.
Pleasure.
I hope you all have a good evening. And for future webinars, please do visit our website, which is www.trenovogroup.com. And stay safe, stay informed, and see you soon, I guess.
Thanks, Ellie.
Bye.
Bye.